Rather, this information provides the opportunity to detect offenders and eliminate the innocent from inquiries quickly. The data bank may act as a deterrent to offending and re-offending, can provide a means of solving cold cases, and will undoubtedly raise public confidence that persons who have committed offences can now be found, no matter how long ago they may have committed these crimes of murder, of rape. They can now be found and dealt with by the criminal justice system. Clause 8 would make provision for the appointment of a custodian and deputy custodian of the Forensic DNA Data Bank. The primary responsibility of the custodian would be to receive and store all DNA profiles from the Forensic Science Center and to carry out searches against the Forensic DNA Data Bank. Mr. Speaker, one of the reasons the Act, which came into force in 2007, remains unworkable, and it is that Act was passed by the parliamentary opposition of today, is the fact that no one has ever been appointed to this critical post of custodian of the Forensic DNA Data Bank. Let me say today that this state of affairs will not be allowed to continue under this government's watch. And on coming into force of this Act, both a custodian and a deputy custodian will be appointed at the earliest opportunity. Clause 9 would set out the circumstances under which the custodian or deputy custodian may resign his office or have his appointment terminated. These circumstances include where the custodian or deputy custodian is found guilty of misconduct, fails to carry out any of the duties or functions conferred on him by this Act, or is incapable of performing his duties under this Act. Clause 10 sets out the functions and duties of the custodian, which includes maintaining the Forensic DNA Data Bank and ensuring that DNA data is stored securely and remains confidential. Mr. Speaker, by Clause 11, the custodian is mandated to submit an annual report of his operations to the Minister within 3 months after the end of each calendar year. In the same vein, the Minister shall cause the said report to be laid in Parliament. Part 4 of the bill, Mr. Speaker, comprises Clause 12 through 23 and makes provision for the taking of non-intimate and intimate samples. Clause 12 would provide that a person may volunteer to give a sample. Mr. Speaker, the value of obtaining samples from volunteers cannot be overlooked. DNA data can only be effectively relied on by law enforcement authorities if elimination samples are obtained. For example, where an individual has been murdered, each police officer who attends the crime scene, the district medical officer, the undertakers, or any other person who may have compromised the integrity of the crime scene should volunteer to give an elimination sample. Similarly, where a woman has been the victim of a rape, her husband or committed partner may wish to volunteer a DNA sample in order to distinguish his DNA from any biological material which may have been retrieved from the rape victim. Clause 13 sets out the circumstances under which a non-intimate sample shall be taken from a person without his consent. Mr. Speaker, before I elaborate on government's policy with respect to the taking of non-intimate samples without consent, which has been encapsulated in Clause 13 of the bill, permit me to give a brief overview of the persons from whom DNA samples can currently be taken, other than volunteers and members of the protective services under the Act. At present, non-intimate samples may only be taken from a person without his consent where A, he has been charged with an offence, B, a stain derived from a crime scene exists, and there are reasonable grounds for suspecting the person's involvement in the crime. C, the person has already had a non-intimate sample taken, and that sample has proved to be unsuitable or insufficient. And D, the person has been convicted of an offense and is serving a term of imprisonment. Mr. Speaker, I am at pains to understand who drafted this last act. I am at pains. And that is why we have had to take the step of repealing that entire act of 2007. It was totally unworkable. It did not provide the law enforcement with the teeth required to get into DNA testing, as well as the use of DNA in prosecutions. With respect to intimate samples, the Act is limited to the taking of an intimate sample from a suspect with his consent or without his consent by order of the court. Additionally, non-intimate or intimate samples may be taken from a person who is in prison or other institution to which the Prisons Act applies, or from a person who is detained at a psychiatric hospital in accordance with the Mental Health Act. Mr. Speaker, the severe limitations imposed by this current legislative formulation were highlighted in Magisterial Appeal number 3811 of 2006. Sean Dilpaul, Corporal of Police, number 13828, against Richard McBain, alias Bean. In this matter, the complainant sought an order under Section 19(1) of the Act to obtain an intimate sample from the accused, Mr. McBain, who was charged with the murder of Stephen Hackshaw. The main question to be determined by the court was whether Mr. McBain was a suspect within the meaning of Section 19 of the Act, having already been charged for murder and the preliminary inquiry already having begun. The court ruled that Section 19(1) of the Act only applied to a suspect and did not apply to an accused person who had already been charged and brought before the court. The court further concluded that since Section 19 made no mention of persons charged or convicted of an offense, as provided for in Section 5 of the Act, the court could make no ruling or order in respect of an accused, but was limited by the section making orders in respect of a suspect. The learned judge, Madam Justice Alice York Suhon, was of the position that if Section 19 were intended to apply to an accused or to a convicted person, then it should have been drafted in terms similar to Section 5. Considering the legislation as a whole, and in the way that it is drafted at present, it is my respectful view that a court may only order that an intimate sample be taken from a suspect and not from an accused already charged with a crime or someone already convicted of an offense. Clearly, Mr. Speaker, the practical effect of the court's ruling was to severely restrict the ability of the police to obtain intimate samples from accused or convicted persons, resulting in a major hindrance to the investigative capacity of the police and an inadequate use of DNA technology. This bill, Mr. Speaker, addresses these deficiencies. Clause 13, therefore, is intended to strengthen the legislation and to assist the police with their investigations by broadening the categories of persons from whom non-intimate samples can be taken. The bill provides that a police officer shall take a non-intimate sample from a person without his consent where A, the person is a suspect, detainee, or an accused. B, a stain derived from a crime scene exists, and there are reasonable grounds for suspecting the person's involvement in the crime. C, the person has already had a non-intimate sample taken, and that sample has proved to be unsuitable or insufficient, or D, that the person is not the victim of an offense, attends a crime scene, and is required by an investigating officer to give a non-intimate sample. Further, a qualified person shall take a non-intimate sample from a person without consent, where the person A is admitted to hospital and is a suspected, accused, or convicted of an offense. B is detained in a prison or other institution to which the Prison Act applies. C is an incapable person who is admitted to a psychiatric hospital in accordance with the Mental Health Act and is suspected, accused, or convicted of an offense. Or D, falls under the supervision of a juvenile residential facility. Mr. Speaker, I mentioned earlier in my presentation that this government has sought to simplify the means by which DNA samples are obtained and to strengthen the legislation so that DNA evidence may be fully utilized as a modern and effective crime-fighting tool. Clause 13 achieves these goals. The consent of the person from whom a sample is to be taken is no longer an issue, and the taking of DNA samples is no longer restricted to suspects or persons charged with an offense. Moreover, police officers will now be empowered to take a wider range of non-intimate samples, including a specimen of blood. Similarly, the categories of persons from whom a qualified person shall take a non-intimate sample has been extended to include persons who are hospitalized and are suspected, accused, or convicted of an offense, and persons who fall under the supervision of a juvenile residential facility. Clause 14 sets out the circumstances under which a repeat sample may be taken from a person who has had a non-intimate sample taken, and that sample A has proved to be unsuitable or insufficient for forensic DNA analysis. B is lost or destroyed, or C cannot be used for any other reason. Provision is made for the police to cause a notice to be served on the person from whom the non-intimate sample is to be taken, or in the case of a child, Mr. Speaker, or incapable person, on his representative. Further, the police may arrest without a warrant any person who fails to comply with the notice, save and except those persons who are hospitalized, detained in a prison, admitted to a psychiatric hospital, or under the supervision of a juvenile residential facility. Clause 15 would provide that a non-intimate sample shall be taken from a person specified in the 3rd schedule to this Act, Mr. Speaker. I have already alluded to the need for having elimination samples lodged on the databases which would form the DNA data bank. Because of the sensitive nature of their employment and as a security measure, it was felt that the following persons should, as a matter of course, provide a non-intimate sample. A person who is employed or applies for employment in the protective services, that is, members of the police service, prison service, and fire service. B, an applicant for or the holder of a license, certificate, or permit under the Firearm Act. And C, a person who is employed or assigned duties at the Forensic Science Center. Mr. Speaker, legislation should never be static, but should always evolve and adapt to the needs of society. It may be necessary in the public interest for other persons to give mandatory DNA samples. Provision is therefore made for the Minister by order to amend the 3rd schedule. Clause 16 of the bill introduces another new concept. That is, where the Minister of National Security is of the opinion that a sample is required from a person in the interest of national security, he may request that the Commissioner of Police make arrangements for a non-intimate sample to be taken from the person. We are all aware, Mr. Speaker, that we live in a global village where threats to destabilize civil society have become a frightening reality. Ever cognizant of this fact, it was felt that stringent measures needed to be put in place to establish